All right, this is 23. Miss Patton, will you tell whoever you're with that you're in court?
Yeah, I told them they don't really care. I'm gonna just go upstairs.
All right, this is 23-1450, the people versus Monica Patton.
Morning, Your Honor. James Galucki on behalf of Miss Patton. Your Honor, Miss Patton is going to plead guilty to the reduced charge of failing to report an accident. I spoke with Mr. Zick. There's no restitution.
Okay, and you understand that failed to report is a misdemeanor, Miss Patton. It could be up to 90 days in jail and a fine of up to $100 plus court costs and statutory fees. Do you understand that?
Yeah.
All right. And, ma'am, did you go over your constitutional rights with your attorney that are on this advice of rights form?
Yes.
Did you understand those rights, Miss Patton?
Yes.
And did you give your attorney permission to sign and date that form for you?
Yes.
You understand that if you plead guilty, there will be no trial and you'll be waiving all those trial rights in this form.
Yeah.
Okay. And you understand if you're on probation or parole and you want to plead guilty, it could be a violation.
Yes. I'm not.
All right. All right, Miss Patton, to the charge of failing to report a property damage accident, how do you plead?
Guilty.
All right. Has anyone forced you to get you to plead?
No.
Has anyone promised you anything other than the plea agreement to get you to plead?
No.
Are you pleading guilty of your own free will?
Yes.
Okay. Miss Patton, were you in the city of Taylor on July 8th of 2023?
Yeah.
And while you were in the city, ma'am, did you get into a car accident?
I didn't, but someone else did that I was with, yes. So I'm just taking the charge.
All right, well, we can't do that. Mr. Galucki, this is the second time this has happened. We're setting it for jury trial because we're not coming back every couple of weeks to try and take a plea. Miss Patton has made it clear. And Miss Patton, no talking. Miss Patton, no talking. Miss Patton has made it clear at her last appearance that she wasn't driving the vehicle. I know you've had further discussions with her. That's still her stance. I'm rejecting the plea. We're not doing a plea. We're going to set it for trial. And Miss Patton, you'll get notice of the trial date, letting you know when you need to come to court, okay?
Okay, thank you.
All right, we'll have a jury trial and we'll see everyone back on that date.
Okay.
All right, we're all set. Thank you. And that concludes our morning docket. I'll see everyone back at 1.
Please, will you hand me my screen box?
Activity free. Wow.
Justicia Mays, that you come on up, please. She's walking very slowly. Is this mine? What are we gonna do today?
Yeah, she was. I think the state wanted to view the video, and that might just over the case.
It's a drug case, Judge. Apparently, they've got some medical evidence that might attest to her being within normal limits of the drug that she was prescribed. However, I want to look at the video.
Say that again now.
I need to look at the video.
Okay.
A little bit of time would help.
So, are you operating a motor vehicle now? Did you drive up here?
Yes, sir.
Okay. Do you have any devices based upon this DWI on your, do you have an interlock device or anything like that?
It wasn't alcohol in this.
I know it wasn't, but I'm just curious if she was ordered to do something.
I don't believe so.
Well, if it's
Not that I'm aware of. I didn't think she was, but she could be. But I wasn't aware of it. The short version of this case is that the intoxicant that she was accused of being under the possession of at this particular time was a prescribed drug by a doctor, and
it could be prescribed, but you can still adversely affect your ability to operate a 4,000-pound missile.
Correct. And then when the blood test came back, from my understanding from discussions with her doctor, she came within the levels of what she would not have been deemed to be intoxicated based upon the level of the absorption of the drug in your system and elimination. Because
Every human's different on that.
yeah, but I think that the pharmacists have different ranges, and that, to my understanding, the range that she was in would not have been intoxicated. But I believe Stacey still wants to look at the video. But
You still won't.
well, and the thing
It's
is,
one thing of some kind of a level, but anybody can reach a level. It says if you're unable to, if it adversely affects your abilities, and sometimes it doesn't take much for some people.
that's true.
But anyway, that's what was the drug?
I was prescribed diazepam.
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 Yes, sir.
And that was the only thing that came back in the blood test. She doesn't drink, no alcohol, no.
I know diazepam is a controlled substance, so it's dangerous, and that's why you have to be careful about it. Anyway, so how much time?
Normal. We said, I guess, whatever your normal is.
4 weeks. 4 weeks.
Works for us, Judge.
Okay, and just have a seat before you leave, and then we'll get you out of here. Devin Walker, you got Devin Walker and Robert Wilkes left.
Wilkes, he's another one that wants to try Walker. I think we're gonna get disposed of that. It's not COVID.
Well, Judge, there's an offer.
Devin Walker, please. Devin Walker, 23 CR 634.
Give you one medicated.
Right, but you said that you would consider.
Yeah, but I'm not gonna change what she did.
So what consider me? You said it's one time to consider.
I'm not gonna lower it. Double check. I'm not gonna give it what it is. That's
Devin, are you Devin Walker? Yeah. 23 CR 634. Okay, what are we gonna do on that?
That's not.
we didn't talk about anything, but
We're not talking.
well, let's be
We
clear.
can do today.
Let's be clear. There was
We're gonna
nothing
do
to talk
today.
about. It was just you say consider. And that was it. That's
Hey,
all.
y'all can fight it out outside.
Wait, yep. Okay. Go.
We're gonna fight, of course, but what do you want to do today?
Well, I mean, in light of what he just said, I think the only thing we do now is just set it for trial.
Set it for trial. It's set for trial. Thank you. It's set for trial, and just have a seat there before you leave. Robert Wilkes, get a reset.
Okay, thanks, Judge.
Robert Wilkes is next. Same thing. What are we gonna do on?
He's one of my public defenders. Judge, I believe he wants to.
Where's Robert Wilkes?
He's here. Well,
He's outside. He's gonna come
Robert Wilkes. He's outside. Thank you. Hey. And everybody listen.
You're right, Judge.
It's like that. You just stare down on them, let the eyes do the work. Your mouth might be saying, hey, we cool, but your eyes are like, no, we not.
All right, you're Sheldon flying out.
Yes, sir.
All right, we'll go on the record in State of Kansas versus Sheldon Tyler flying out 23 CR 300,025. The state appears by Devin Canfield. Mr. Flying Out appears in custody from the Butler County Jail. All parties appearing by Zoom. Mr. Flying Out, you're here for first appearance. Do you have a copy of your charges yet?
Can I say something, Your Honor? I've had my first appearance for this 7 months ago, exactly yesterday. I've been in this county jail for 7 months for this case.
Mr. Canfield, do you have any?
And my court was set for the 17th and 28th of this month. That's why I was shocked whenever they said I was coming to court today for this exact same charges that I was here for are already on.
All right, just a second, Mr. Flying Out. I'll see if Mr. Canfield has any information for me.
Yes, Your Honor. It appears that this case was originally filed as a traffic case because my office was waiting on additional information. Then to amend the complaint, we were told we would have to dismiss the entire case before refiling as a criminal case. We did that, and we did not, I do not believe that the jail was informed. So that is the reason that he has been in custody for this amount of time. But this is the first appearance on the criminal case.
But when did he make that? He made a first appearance under the old case number?
Yes, Your Honor, in a traffic case as it was filed back then.
And what was the date on that?
It appears that the first appearance was on May 8th of this year.
You've been sitting in here since May 8th?
My lawyer hasn't talked to me or nothing. I haven't seen him I've seen him one time, and that was for my court I had court for this and all the other stuff on July 24th, and they still didn't tell me nothing, and it got continued on until November 17th to 28th. And my lawyer still hasn't talked to me, seen me or anything in that. And today, like, if it was going to be my lawyer, I was firing him because, like, I've had no counsel help or nothing. And I've been sitting in C-Pod Max this whole entire time on these charges. And so, with not knowing anything that's going on.
Mr. Canfield, when was the other case dismissed? Do you have that info?
Let me take a look, Your Honor. It looks like that previous case was 23 TR 1680. The dismissal journal entry was filed on October 30th of this year.
Well, Mr. Flying Out, I'm going to go over these charges with you under this case number. Sounds like perhaps they were read to you before, but for purposes of the record, I'm going to go over them with you again.
All right.
There's quite a few.
Yeah, there's 14. I see. When there's 14 on them, and that's what it said in the computer the whole entire time. But when I came to court, like my first appearance, they read all 14. Then when we went to court on the 24th, they only read 3, and they were only charging me for 3. And Watts asked me if I had stuff amended, and I was like, no, I haven't had no contact with nobody. And he said we should just go to court then with those 3 and be done with it. But then I continued it out, and now this is happening.
Okay. Well, each of these counts is alleged to have occurred on May 7th, 2023 in Butler County, Kansas.
Yep.
Count 1, it's alleged that you were in unlawful possession of scales with powder substance. That's possession of paraphernalia to distribute or manufacture. That's a level 5 drug felony. Count 2, you're charged with recklessly causing bodily harm with a deadly weapon against Melody Brown, wherein great bodily harm, disfigurement, or death could have been inflicted by means of an automobile. That's aggravated battery. That's a level 8 person felony. Count 3 also charges aggravated battery, alleged victim. In that charge, Brett Steiger, also alleged to have occurred with a car. Again, aggravated battery, level 8 person felony. Count 4, you're charged with criminal damage to property, a level 9 non-person felony for allegedly causing damage to a driver's side door and mirror on a Dodge Ram truck belonging to Brett Steiger. Alleged value at least $1,000, but less than $25,000. Count 5 alleges unlawfully and knowingly damaging, destroying, defacing, or impairing the use of a F-150 truck by running into the back of it, causing it to wreck into a ditch. That vehicle belonging to Melody Brown has a value of at least $1,000, less than $25,000. That's criminal damage to property, a level 9 non-person felony. Count 6 alleges interference with law enforcement, a level 9 non-person felony. Count 7 alleges fleeing or attempting to elude an officer by reckless driving. That's a level 9 person felony.
Okay, everything except attempted murder.
Attempted murder. The list goes on, and so on, and so on.
Count 8, you're charged with leaving the scene of an accident. That is a Class A non-person misdemeanor. Count 9, you're charged with driving while your license is suspended or canceled. First time offense, that's a Class B non-person misdemeanor. Count 10 alleges you're operating a motor vehicle without proof of insurance. That's a first offense, Class B non-person misdemeanor. Count 11, you're charged with failing or the duty to give information after an accident. And it alleges that you unlawfully drove a motor vehicle, a silver Mazda 6, which was involved in an accident resulting in damage. to vehicle or property being a white Ram truck belonging to Brett Steiger and failing to give your name, address, and registration number. That's an unclassified misdemeanor. Count 12, you're charged with reckless driving, first offense. That's an unclassified misdemeanor. Count 13, it's alleged that you operated a motor vehicle with an expired tag or registration, first time offense. That is an unclassified misdemeanor. Count 14 alleges you are speeding 60 miles an hour in a 30-mile-per-hour zone.
This is the song that doesn't end. Yes, it goes on and on, my friend.
Do you understand your charges, Mr. Flying Out?
Yes, I do, Your Honor.
All right, this case has been assigned to Judge Hart. Your next court date will be February the 5th at 2:30 in the afternoon. That'll be done by Zoom. That's Judge Hart's felony preliminary hearing control docket. February 5th at 2:30.
Can I get a different lawyer?
Who was appointed to represent you on the old case?
James Watts. And he hasn't helped me at all or done anything or spoke to me or wrote, like, sent me paperwork or nothing. Like, I was going to fire him at court. So if there's any way I can get different counsel, that'd be really nice. I've been sitting here for 7 months and not even a word of anything that's going on.
Well, Mr. Watts has a contract with the county. Perhaps since it's been refiled, you'll have a fresh start on getting everything worked out.
No, I've tried calling him. I've tried sending him letters. I've tried having my people getting a hold of him. Nothing.
Where do you live, Mr. Flying Out?
I live in Barber County, Medicine Lodge, Kansas.
Okay, how long have you lived there?
I've lived there since I was a kid, since I was born. And back and forth, off and on from Wichita to Medicine Lodge. And I just moved back home.
Do you have any relatives in this area?
I don't have no one up here. I've been up here for 7 months with only $20, $30 on my books. This whole entire time. Nobody.
Do you have work to go to?
Yes, I have a job at a tire shop and everything.
And how long have you worked there?
I've worked there for 3 months before I came in, and I've talked to my boss since I've been here.
Okay. What I'm going to do, Mr. Flying Out, in light of the circumstances, I'm going to set a $5,000 OR bond. I'm appointing James Watts to represent you. If you're welcome to hire an attorney of your choosing, but Mr. Watts is appointed for you at this point. So,
Sorry, go ahead. I apologize.
Do you have any other holds on you?
I have a Harvey County hold, but they already have a bond and a warrant, a bond on top of the warrant for that. So I'll be able to bond out of both.
Okay. Well, once you're released from custody, you need to call Mr. Watts's office, give him your contact information of where you're going to be.
All right.
Mr. Canfield, anything you would add?
Your Honor, I would request no contact orders with the victims Brett Steiger and Melody Brown, as well as no drugs or alcohol.
Yeah.
That'll be the order of the court.
Does that $5,000 bond take over the last bond I've been sitting here on?
It sounds like that case was dismissed.
Dismissed, so all right.
But again, I don't have any of that paperwork in front of me. I'm just relying on what I've been told here today in court. So
all right.
They should have written that court date down, and they should have Mr. Watts's information for you.
Yep. Thank you.
All right. We'll be in recess. Thank you.
All right. Thank you. Hello.
Good afternoon. Are you Michael Centeno?
Yes, sir.
All right. Next case is State of Kansas versus Michael Angelo Centeno, 23 CR 300,026. The state appears by Devin Canfield. Mr. Centeno appears in person from the Butler County Jail. You're here for a first appearance. Have you received your charges?
Yes.
All right. Count 1 alleges that on November 6, 2023 in Butler County, Kansas, you did unlawfully possess methamphetamine. That is a level 5 drug felony. Do you understand what you've been charged with?
I know what I'm being charged with. I don't know the consequences.
Okay. Well, a level 5 drug felony, if convicted, would carry, depending on your prior criminal history, a penalty of anywhere between 10 months and 42 months in prison. If you have 3 non-person felonies or less in your criminal history, it's presumed you'd be placed on probation if convicted. If you have 2-person felonies or more in your criminal history, it's presumed you'd be placed in prison. There's also a maximum penalty of $100,000 fine. So those are the maximum penalties. Does that answer your question?
Yes.
Mr. Centeno?
Yes.
Okay. Since this is a felony charge, you won't be asked to enter a plea today. Your case has been assigned to Judge Ricky, and I'm going to place your next hearing at December 18th at 2:30 p.m. for felony preliminary hearing control in front of Judge Ricky. That will be done by Zoom. Can you afford to hire your own attorney? Mr. Centeno, can you afford to hire an attorney to represent you?
I'm screwed. I don't have anything.
That meaning you don't have any money?
I don't have anything. I don't even know how to respond to something I purchased with $10, and it's like my whole life in your hands right now.
All right. Well, Mr. Centeno, I don't want you to make any statements that could be used against you in the future. So let's not talk about the facts and circumstances of your case. Can you afford to hire an attorney, or are you saying to me you don't have any finances? All right. I'm going to appoint James Watts to represent you. You may be required to pay back some or all of his fees if you're convicted, but that way you'll have counsel representing you. We need to set a bond. Mr. Canfield, what's the state's recommendation for bond?
Your Honor, looking at the criminal history, it does appear to be...
Mr. Centeno,
Yes.
you need to remain seated. You're still in court.
There does appear to be some violent criminal history, as well as current Sedgwick County cases. For that reason, the state is requesting a $5,000 cash surety bond, as well as no drugs or alcohol.
All right, I'll set bond in the amount of $5,000 cash or surety. As a condition of bond, you're not to possess or consume alcohol or illegal drugs. Mr. Centeno, if you're able to make bond, you need to call Mr. Watts' office. They should give you his contact information there at the jail. Mr. Canfield, anything further on Mr. Centeno's case?
No, Your Honor.
All right, Mr. Centeno, now you are excused.
God bless you. But how do you pronounce it? It sounds like you sneezed. A snafu. That sounds like sneezing. You know, it is. I would like the derivation of snafu. Where that? Oh, it's
situations on the law.
Okay.
Yeah.
Daryl Cooper. You're Daryl Cooper. Sorry, Mr. Cooper. I don't have to tell I don't have to tell you. You know that you got cocaine in your system.
Bingo.
Where's his file? Did I give it back to you, Daryl Cooper? Oh, hang on. And his bond is what? That's Mr. Adams, I guess, is your attorney. What was his bond?
It was $5,000.
Okay. Your bond, you have failed this drug test. You have cocaine in your system. And your bond is revoked. It is doubled to $10,000. Plus, you must have a drug patch as a condition of bond, because the very first condition of bond is do not commit an offense. And illegal use of drugs, cocaine, is an offense. So you will be taken into custody. And Mr. Walker, that's you. Come on and get a resetting. You're free to go. You got it? Okay. You're free to go. He's in custody. Yeah. When you flunk the drug test, you're immediately taken into custody. I have Mario Hernandez. Come on up. 2240195 is called Mario Hernandez. That's you?
Yes, sir.
Present. With Mr. Kelly, your attorney in the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
We do, Your Honor.
In summary, this indictment alleges that on or about March 10th, 2021 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, prosecuted for the lesser included offense of what is the offense?
Indecent assault. I said,
What's the section number, please? I got 22, I guess. You would be pleading guilty to lesser included Class A misdemeanor indecent assault, which is found under Section 22.012 of the Texas Penal Code, which carries with it up to 1 year in the county jail and or up to $4,000 fine. Do you understand the punishment range?
yes, sir.
The agreement is that you would be placed on deferred or unadjudicated probation for 2 years. Is that your understanding of the agreement?
Yes, sir.
Also fined $500.
Yes, sir.
If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this Class A misdemeanor, lesser included offense under this indictment? Indecent assault, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. I think I understand all of this here. How old was the child? 10 years old?
Yes, sir.
The only difference between this and the second-degree felony of indecency with a child is the fact that y'all just dropped the age of the victim, right, as an element.
Yes, sir.
Everything else is the same.
Yes, sir.
Okay. All right. Anything else?
Not for much.
Okay. It looks like sex offender registration is not required yet.
It's not mandatory, no, sir.
And it didn't get passed in this term, I guess.
No, sir. Not to my knowledge.
The statute says it's sexual offender registration is not required, and then it's in parentheses yet. So apparently, for whatever reason, they elected not to. The legislature elected not to change that other code. All right, and the defendant has entered his plea of guilty to this Class A misdemeanor. Is a pre-sentence report waived?
Yes.
Anything else to add? If not, I'm going to find Mr. Hernandez, you have pleaded guilty to this Class A misdemeanor, the lesser included offense of what is referred to as indecent assault. And under Section 22.012 of the Texas Penal Code, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I am going to follow this agreement, defer any finding of guilt, and place you on deferred or unadjudicated probation for 2 years. You are fined $500. There will be terms and conditions of probation, which are normal and customary for this type, a general type of offense, even though I want him to go to sex offender classes and other things like that, that are normal and customary for other types of the offenses. And especially in light of the fact that the complainant was 10 years old at the time of this event. There will be other terms and conditions of probation which are normal and customary for this. Now, you're also going to do 180 days in the county jail. This is a crime of indecency. A 10-year-old child is victimized. You're going to pay a price for irreparable harm to a child on my watch. I just wish it was more. You took advantage of a 10-year-old more than once, according to the probable cause affidavit. Except for everybody just dropping the age It's a second degree felony. Plus mandatory reporting requirements for life, I believe. What this court can do in managing the fair and appropriate remedy that I guess we can assess, although how do you take back the harm to a child? There is no way. You took advantage of a child. I have no sympathy for you. I have sympathy for the child. You took advantage of a 10-year-old child. Shame on you. You're going to jail immediately, 180 days, as a condition of this probation.
Your Honor.
Anything else?
Yes, Judge, if I may, considering that he's employed currently, will the court allow us to break that up in some way? I don't have something to proffer to the court right now, but I would at least like to ask the court to,
Let me just say,
to consider.
Mr. Kelly is one of the most wonderful people I know. And he's a wonderful attorney, as well as just being a very fine, great man. He has children, and I know what he thinks. I know what we all think. You didn't give this child a chance to get ready for your assaultive behavior. And you did this more than once. And I have no sympathy for you. I'm not going to work on your terms, in spite of the fact I would do almost anything for Mr. Kelly. This doesn't have anything to do with Mr. Kelly. He's trying his best to help you, but he cannot undo your terrible misdeed. It was an unnatural act you performed on a child. Shame on you. You're going to jail. The most I can put you is 180 days. And that's what you're getting. That's what we call justice under these circumstances. Unfortunately, we can't undo the assault that you performed on a 10-year-old child. Shame on you. Anything else? That's, in all due respect, if it was any other kind of circumstances, Tom, but I feel sorry for that child. That is all. Well, now, sorry, Tom's case, where Tom, let's go back to that. There's an issue that was brought up. Do I have anything else on this, or is that clear me?
You have Tyler. That was the one. The competency. The competency. You said you wanted to leave it for last.
I'm certainly going to leave that for last. Okay. What you're saying, are you saying that Class A misdemeanors, I cannot order confinement in more than what?
No more than 30 days, Judge.
No more than 30 days. And what's the site on that, please?
42A point 42A.
42A.
Point 302.
Confinement. 30 days in a misdemeanor case. Okay, that's pretty clear.
Yes, sir.
That it cannot be more than 30 days. Thus, it is the condition of probation is 30 days confinement in the county jail, not 180. And such will be corrected. Anything else?
Judge, I'd like to re-urge my previous request if the court would allow me. My concern is 30 consecutive days may end up costing a job. I'm not, Judge, I'm not in any way
No, you're not. I know you're not. I know you're not.
I'm asking on my client's behalf, and I think I have a duty to ask. I think it's important.
I appreciate it. I appreciate it. Yeah, I've considered it, but I'm not considering it long because he didn't give that little child opportunity to make a choice. And I'm not giving him any, I'm not making it I'm not making it convenient for him. I'm sorry. I'm sorry for the child. I'm sympathetic with the child. He shouldn't have done that. And this is one of those cases where it's a second-degree felony. Second-degree felony, according to all the circumstances of the case. How y'all want to work that out, and that was something presented to me. And there may be some things I'm not aware of, but all things being the same, for what I believe in and what I believe the whole law was based upon, is that when you commit indecent assault on a 10-year-old child, you must pay a hefty price. That's only fair. I'm standing by that. He may lose, but I'm sure that child will never forget. That's what drives my actions, is the harm to a child, which can't be undone. Okay, that is all. Thank you.
Excuse you.
Yes, give them that resetting. But yeah, if you can post $100,000 bond on your own, you can hire a lawyer. Thank you. On Malachi Hughes, come on up, Mr. Hughes. You flunked your drug test. You're under arrest. Your bond is revoked.
Seriously.
Your bond is revoked. Where's his fine? One of the conditions of bond, of course, is you don't use drugs. I need Malachi Hughes to file.
75,000 on each case.
Your bonds just got bumped up to 150,000 for each case. It's doubled for flunking a drug test.
And
This seldom happens like this, but there's a lot to lose. You've tested positive for marijuana, so your bonds are revoked. They are doubled in each case. You have to have a drug patch as a condition of bond, and you are taken into custody. And I want to review him in a week just to make sure that if he's able to post those bonds, he's able to get out. I just don't want him rotting in jail. Okay. Thank you. You're in custody. Thank you. See, it takes 10 minutes to get somebody from outside in here. We just,
I know
have things to do.
That's his wife, and that's him right there.
Take your hat off.
That's not mine.
Who's got the hat? Take the hat. Thank you. You can sit outside, ma'am. You can sit outside for a second. I ordered you to be outside. Thank you, ma'am. Yeah, with the hat. Thank you.
Oh, okay.
You know, criticize the court when he's enforcing rules. You got a lot to learn about rules, apparently.
He doesn't speak any English.
He kind of stumbled on that word, didn't he?
Yeah, when he had come to my office, I misspoke. I said wife.
Who are you?
The cousin-in-law.
Ma'am?
Cousin-in-law.
Well, really? That's about okay. Well,
she's the one that came to office.
Close enough for government work, right?
That's it.
You are Jorge Lopez? Okay.
And Judge, if you don't mind, I'm not.
This is an initial appearance, and what is your full name?
Ashley Hooks.
Okay, raise your right hand. Do you solemnly swear or affirm that you will interpret into Spanish, I guess is the language he understands, from English, and from Spanish to English so that the court reporter and all of us can understand his answers after I give him these questions? Will you do that, so help you God, correctly?
Yes, sir.
Lower your hand. And when you tell me what he's saying, just speak exactly what he says. Sometimes that sounds awkward, but just say exactly what he says, okay? Are you Jorge Lopez?
Do it as Jorge Lopez. Yes.
Good. Oh, you caught on very well. We can use some interpreters here, so I might get you on the list. Malachi Hughes. You are Malachi Hughes?
Yes, sir.
And Mr. Adams is your attorney?
Okay, I think this is
Correct?
No, my attorney.
Have you ever met him?
No, not.
Oh, okay.
He just
Well, okay. Well, he's a very good lawyer. You must have told someone at the jail, one of the magistrates, that you were going to hire your own lawyer. Are you able to hire her? Are you
Call back and we'll call you out.
There are several hundred lawyers around here. You can't turn without running into them. So they're easy to find, but he's an attorney. Before I'm going to allow him to represent you at the cost of the taxpayers, which is not fair to the taxpayers. If you're in trouble, you got to take care of your own trouble, like I do, like everybody does. That's the rules. And taxpayers don't like to pay taxes so other people can ride the free train of legal help when they get in trouble, unless some folks are just unable to pay, and that happens. And we try to help them get back on their feet so they can become independent rather than dependent. Dependent is not what we're all about. This is independence. We're independent people. But some people always need help from time to time. And that's what we're here to do, is get you independent. Do you work somewhere? How are you going to hire your own? It says we'll hire our own. How would you do that? Through your family or something? Well, your family shouldn't be paying for your mistakes. You're a grown up. What are you, 19?
Yes, sir.
Yeah. I'm sorry. You've been a grown up now for over a year, and you got to take care of your own business if you're getting a mistake. And you've got a couple of mistakes, 3 of them that are disturbing. You're charged in 23 CR 963 with the 3rd degree felony of deadly conduct by knowingly discharging a firearm in the direction of individual. You're also charged with the same offense. I guess it's another person.
Yes, Your Honor, that was the 3 individuals at that scene.
Well, there's only 2 discharges. I've got an aggravated assault on the other.
And yes, sir.
And these are 2 3rd degree felonies, which means you're facing up to 10 years in prison for each case. 20 years added. Plus, we've got an aggravated assault with a deadly weapon on that same event. And it looks like there's a 3rd individual who is a complainant. And this person was shot by you, apparently.
That's correct, Your Honor, in the foot.
And if convicted of this, you're looking at up to 20 years in prison. So total, you're looking at up to 40 years in prison. And if you go to prison, you're going to, it looks like under these statutes here, you would have to serve at least 50% of any prison sentence before you are paroled. So that's very serious. What are his bonds on those first 2, please? You've got a bond of $75,000 on the aggravated assault, and the other 2 deadly conducts are how much? Hold on, I'm asking her. I'm not showing it in this file what his bonds are in those cases.
He had a $75,000 bond.
He's got 3 cases. But He's got 75,000. I did that one because that's my handwriting on that case. But I haven't seen these other two. I don't know who.
If it's 75,000, I wouldn't bet it with Benjamin Collins.
Well, I mean, for aggravated assault with somebody's shot. Yeah, on each one?
I'm gonna check the other one, but on the first one, yes.
No, I know. Okay, go ahead.
You said the deadly conducts?
The two deadly conducts.
Right. So the 0963 was 75,000.
We got a new system that's so fast now that it takes 10 minutes.
75,000.
All three are 75,000?
Yes, sir.
That's 200. That's almost $250,000 in bonds. Who posted your bonds?
My father.
Your father did?
Oh.
Say what?
You owe him a lot. That's a fortune for most people. That's just getting you out of jail for whatever mess you got yourself into. That's nothing to do with dealing with the dispositions in this case. Well, you can, if you have access to funds where you can post almost $250,000, then you can go hire your own lawyer. He's a good lawyer. He can get hired too. And where do you live? In Beaumont? Yeah. I'm going to keep him handy for you to refer to and call if you need any advice. But if you can afford to post $250,000 bond, which very few people in this court can do who come to this court, then you can hire your own lawyer. The taxpayers aren't going to pay for your lawyer. I'm going to give you 4 weeks to get a lawyer on that. Now, okay, what do you do during the day if you're not employed and you're a grown up? What do you do other than getting arrested?
Pick up metal, bring it to the
Sir?
scrap yard. Pick up metal.
Collect metal?
Yeah. And Uber Eats, DoorDash.
All right.
All time for fishing.
Yes, sir. All right. You've got 4 weeks. I'm going to ask you to get a resetting here. Take a seat before you leave. You got to do something, and then you can get information from Mr. Adams so you can call him if you need to. And if you want to hire him, certainly he's more than available, and he's a very good lawyer. All right, get a resetting, 4 weeks.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.